better?
Yeah.
Okay, the next item on the agenda will be the reading of the minutes of the previous meeting.
You're not going to get them. No.
February 17th.
What was the first item?
A roll call, sir.
Oh.
No, it wasn't. No, it wasn't.
Would the board like me to read the minutes?
You have to request
These are the
that
minutes of
24 hours in advance in your own name.
Shit, if I stand behind her, who's gonna stop?
I make a motion to waive the reading of the minutes of the February 17th meeting and to accept as is.
I second.
Okay. Anyone opposed to the waiving of the meeting, the reading of the minutes? No. The next item on the agenda. The next item on the agenda, and I've brought this item up early in the agenda just to facilitate the attorneys that are here. It's the pending citizens claim between International Village and Citizens Insurance. And this is a suit we are filing against Citizens through our attorneys Garfinkel, Katzman and Garfinkel, to recover funds that were expended for work done to the building and work that needs to be done. The reason we are here, the attorneys have presented an amended agreement. The agreement was signed early last year, early last year, and some changes were made and amended. Agreements have been brought to us. Basically what they are, we've got an attorney who represents us in the suit, and we have an appraiser who did the actual walkthrough of the buildings and put together the losses that we suffered. What it is, the total cost to the association is basically 40% of whatever is taken in from the settlement. What this new arrangement is instead of paying 40% directly to the attorneys have worked out with their appraiser that the appraiser will get 5% of the takings, the attorney will get 35%. So it's back to the same 40%, just how it's allocated. If the attorneys are here, and if you wanted to address anything in those agreements, they're willing to shed some light forward about it.
Do we have copies of those agreements?
Okay, George is gone. We received the copy tonight. George just went to get it.
Thank you.
Brian is the attorney from.
Hi everybody, nice to see you. I have a question. I do remember most of you, I think. Sir, we haven't met just until this today. So we have seen you. Can you hear me?
Yeah.
No, turn it on.
May that be on?
Hello? Is that better? Hello? Hello?
Yeah, it's
There you go. We have a contingency fee agreement with International Village. That means,
Brian.
can't hear me?
No.
Hello?
Yeah.
Better? Sorry, I'm not a singer. We have a contingency fee agreement. We've probably been working with the board for about a year now. We've been handling this claim with Mr. Lieberman, not formally. Mr. Lieberman was a member of the public adjusting firm that used to work here when you got some monies on behalf of the community from citizens. He branched out on his own, and we're very comfortable working with him now. We've been dealing with him on some other claims as well. He does a really good job, and he's basically agreed to do all the scope on our property, to act as the expert if we have to go to court. And he has been so intimately familiar with the community, he's been just about to every unit before we were even hired. So what we've done is, instead of expending money and getting new experts out here, we decided to use Mr. Lieberman, with your permission, of course. And in return, his fee would be 5% of our 40%, meaning that our new agreement would be we get 35% instead of 40%. and the 5% we pay, we don't pay, you pay, but it's allotted to Mr. Lieberman for his services as a cost. And the reason that that works well is because a lot of people out there in the community these days ask for money up front, and we would have to front that for you, or we would have to ask you for it in terms of engineering fees and things like that. So he's willing to take the risk, as well as we all are, that if no one gets paid, he's going to be working basically for free as well. So he has a stake in the matter to get as much money as possible for us, and he gets the 5%, we get the 35%. That's the only change that there is going on right now. But I just want to talk really briefly about the 40%. People think, wow, that's a huge amount. The 40% is the amount of money that we get. We take that out of the gross proceeds to the association. Citizens Insurance Company has to pay a portion of those proceeds, or maybe possibly all of them, because this is a first-party claim and they have to pay our hourly rate. So part of that money in the gross proceeds is going to be costs, attorney's fees, prejudgment interest, all those types of extra contractual things that don't have to do with the damages. So in other words, the 40% comes out of more than just, we don't take 40% of the roofs. We take 40% of the total amount of money that we either settle for or that we get awarded by the court. The jury would award the damages and the judge would award the attorney's fees and costs. So all that stuff being said, there's a written authorization that we have from the board for $1 million in your pocket. So whatever this contract says or whatever this does, we're not authorized to settle this case at this time, even if Citizens wants to, which they do now finally, and for anything less than $1 million in their pocket. So if we get close, then we may do something with our fees and make arrangements. If not, we might get more than $1 million. We're hoping to get a lot more than that, but that's the authorization we have right now. So regardless of how these percentages come out, you would be made whole in your $1 million, or we would not settle this case. We would go forward to a trial. Just for a very briefly, I could talk forever, but very briefly, what happened recently is we submitted all of our documentation to Citizens, probably 3 or 4 months ago. After we reviewed it, we had Greenberg Traurig, a very large law firm, review our documents too to make sure everything looked completely on the up and up. We handed it all into them. They responded by saying they wanted it to interview people and they wanted to talk to everyone and blah, 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 delay tactic again. So with the board's authorization, we filed a lawsuit. They answered the lawsuit recently, and we've asked them for discovery, and we want to depose all the people that were around in this community with Citizens, whether they still work there or not, to determine why they didn't pay off on this claim. So we have those set up for the next 2 or 3 months, and in return, the opposing counsel, Mr. Fishman, who we have probably 15 cases with, his firm out of Coral Gables, wants to do a reinspection and try to mediate this case. So the reason we're here today, kind of on a quick spur-of-the-moment kind of thing with getting these contracts we've been contemplating for a while, is because they hired a general contractor, Citizens hired a general contractor finally, a new one, supposedly a neutral one, to come to the property tomorrow with Mr. Lieberman at 10 o'clock to do a walk to see how many people he's going to need to come and do a new scope, totally new scope of damages at the behest of their attorney, Citizens attorney. So that's something that's exciting. We've been waiting for this for months. This is done by court order. This is a court-ordered reinspection. This is their time, their inspection on the premises, so they can't just keep dilly-dallying and delaying. If they don't come out here in good faith with 5 or 6 people out here to do a neutral scope of the damages finally, then we go to the court and file a motion to compel and try to get some bad faith against Citizens even though they think they're immune. So this is a more serious thing than a guy just going to come out and take a look around and walk out and never pay any money. And that's happening, like I said, tomorrow. But you'll be notified as to when the people might want to come one more time into your unit if they have to, at a later date. They're coming at this point to see how large the community is, how long it's going to take them, how many people they need to actually do an adequate scope of the damages. And we have a lot of new damages, including a lot of windows that our window experts have seen. So it was an ongoing process. I think that our estimate is completely, perfectly finished. At this point, we submitted it in. We got Greenberg Traurig to look at it, and we're very comfortable with it, that it's exactly what's due you and what we think is a result of the hurricane. So if it doesn't work out and they do a reinspection and 20 days from now they don't want to pay and they don't want, they want to fight it, then we're going to fight it and we'll notice the case for trial. We can't notice the case for trial until we have a hearing on the defenses that they raised and their answer. And that will be probably within the next 30 days. We'll have a hearing on that. We have a hearing on that, whether we win or lose them, it doesn't matter. At that point, the case is at issue. There's an answer and a complaint. And then now you can file a notice for trial, which will be in, say, like I said, the next 30 days. A notice for trial gives, the judge gives you a schedule, a calendar. And the calendar will be posted here. And it says the deadline for discovery to end, the deadline for our experts to be deposed, the deadline for motions in limine, blah, 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 and then your trial date. So everyone will know what those dates are and how long you would have to wait if you had a trial. And our firm just recently, I don't know if everyone's known, but I like to say this because it was a pretty big thing. We just recently got a $20 million verdict against QBE on a case called Buckley Towers that happened about a little over a month ago in federal court in Miami. So that was a big blow to the insurance companies. Citizens knows all about it, and your case is actually pretty much in line with the next ones that we get ready to try. So that's probably why, one of the reasons why, other than the hard work I think we've done. Other than that, I think that's why they immediately make the phone calls and say, what can we do here? Let's go take a look at the property again and see what we can do. So that's where we are now. Hopefully that this will be signed and you won't have any other questions, but if you do, please let me know. Nothing has been really changed in the contract other than our new firm is called Katzman, Garfinkel, Rosenbaum. We had a couple of mergers since that first contract, where it was just Garfinkel Trial Group and Lee Katzman.
Excuse me, where is the, I thought we were going to be dealing with the appraisers that Katzman and Garfinkel hired after we signed the initial retainer agreement. What happened to them?
Well, we're in a period right now that we're in litigation. So we use their estimates, Mr. Romaine and some other people around in the community, especially the window expert people. We've used that and we've gotten a compilation of all the damage.
Yeah, but they were the people, those ones that you put a lien on the village for.
That's because that's just something that I wouldn't want to address in an open meeting, but it's something that we've handled and it's between us and them and not you. So, and that's been ironed out. But we can't use them as experts in court.
So now we're going back to our previous appraisers.
Well, the previous appraiser is actually signed. We have a signed release from the previous appraiser. His name was Mr. Galante.
Yes.
He's from New York. He signed a release saying he's no longer entitled to any monies if we ever get any new monies. And I can present that to the board. I forgot to bring it today. We just got it. So he signed a release on that company's behalf saying that they're not entitled to any more proceeds. They haven't done any work for it.
What has changed that we now have to pay the appraiser directly rather than paying you directly?
Nothing has changed other than the fact that instead of paying him up front, he's willing to take the money in the back end like us. Take the 5% of the back end like
That's
us.
what I'm saying. The original agreement we had with you, the original agreement we had with you, we gave you 40% of the proceeds. And you took care of it. The appraiser took care of it. What has changed now that we are going to be dealing directly with the appraiser? Rather than everything is going through you?
Because the appraiser we're using right now is a public adjuster. The public adjuster is allowed to take a percentage because he's a licensed public adjuster. We can't commingle our funds taking a percentage. We can pay someone $5,000 something to do engineering work, but we can't commingle our funds in terms of giving someone that's a non-lawyer a percentage.
But we
So-
were paying the other adjuster through your funds. I asked you again, when did it change? You were paying the other adjuster through your funds, and now you're asking us, now you're asking us to pay him because you say we can't commingle. But what we commingle with is ready.
The other adjuster was fired before we got hired on this case, Mr. Galante. You got money from him, and he was fired before we were ever on this case. We never dealt with Mr. Galante, never paid him a dime or did anything with him, with that public adjusting firm.
Who did we sign the original contract with to do this?
That's me, that's us. I'm not Mr. Garfinkel, but that's my
I'm
firm.
asking again, what's changed? You're the same lawyer.
Right.
You're the same lawyer that we had, and you're the same lawyer now. What has changed that we have to pay the adjuster 5% out of proceeds? Well, we didn't have to do it before. Please give me a straight answer on that.
The straight answer is we're charging 35% instead of 40, so that the public adjuster can get his 5% for the
Again,
work.
you're not answering my question. What has changed?
What's the reason for the change?
The reason for the change is we'd like to use Mr. Lieberman's services as our expert in court and to prove the damages.
The answer, what has changed that we're paying him out of the proceeds rather than you paying him out of the proceeds? I still haven't got an answer on it. Before you were paying it, now you said you can't pay it. I'd like to know why, what's the change?
We've never commingled funds with anyone. We haven't been working with anyone or paid anyone in terms of percentage.
But you were
Until-
paying the percentage.
I think that's what the gentleman is trying to say, Paul, and I don't quite understand it either. Is that you're not in a position where you can pay a percentage to this person.
Not out of our
And
percentage,
you
no.
can't pay him out of your share of the proceeds, correct?
No, you can't do that by law.
by law, it has to
It's
come from the
ethically-
association.
Brian, this is just a guarantee that the appraiser gets his money.
It's just our lowering our percentage 5%, so that we can use Mr. Lieberman on the back end of things
I read this.
to do
Can
that.
I have the microphone, please?
I'd love to clarify.
I
Pretty straight shooter. I don't know what else I can say.
Brian, I read this, and it says that we're gonna pay you 5% of the total,
Hey, Mr. Lieberman's firm,
of the total,
of the gross proceeds.
whatever the proceeds, but it doesn't say what proceeds we are guaranteed. So as far as I'm concerned, this is not written correctly. It should say, what we're doing here, if we sign this, we're obligating ourselves to agree to pay 5% of the proceeds, but does not state that we must get $1 million net. So if you would say that we get $1,660,000, will you agree then to pay 5%?
Absolutely. That's a separate
It
matter.
doesn't say that.
Well, if you wanted to say that, it's
So
no
we
problem.
can't sign this then.
In other words, the original contract said that we net $1 million. That's what we agreed.
Right, that's a
But it doesn't say that
notarized,
here.
that's a notarized agreement.
Yeah, but it doesn't say that here.
That's because this is a contract. These are contracts for services.
Then it must
The other
say,
one-
it must also guarantee, because what if we don't get $1 million? What if we get 900,000? Forget what happens, that's all they want to get. So we lose, we still have to pay 5% of the 900,000, right? This is no good, you gotta put the number in.
I'll be glad to put the number in there. But just to explain that, if we went to trial, look, we're not going to settle this case because we think that the $1 million in your pocket is reasonable. And we're trying to get more than that.
You understand?
Right. Let's say we pulled the trigger, we agreed and we pulled the trigger and went to trial, and you got zero, or you got $100,000. The guy still should get paid for all his work he's going to do. That's what that means. But I can put it in there that,
Whoa, wait a minute. Originally, Garfinkel said it won't cost us 1 penny. You absorb all the costs.
that's true.
So even though he deserves his money, not from us, we wanted the original $1 million. We'll give you the 40%, 35 and 5, but it's got to state that there. If not, we're not guaranteed.
We guarantee that.
We're not lawyers.
We'll guarantee you money, provided that we get a gross payment of $1.6 million.
Net.
That gives us $1 million net. That's all we want to say, so just put the numbers in, we'll sign it.
I'll put the numbers in there, obviously. Let's just say the citizens will never agree to pay us $2 whatever million or whatever it is. And you're not going to get your $1 million net unless we go to trial. Going to trial, there's always a huge risk. I mean, you can get zero, you can get $10 million, you can get $20 million like we got. But let's just say you didn't get your $1 million and we agreed to go to trial. And the facts came out as they were, and you were entitled by the jury to $500,000. We're not going to get paid zero for that. I mean, that's a decision that we all make together. And if we roll the dice like that, then the contract should start.
We're already guaranteed by
We said you had
that's
the
why
right.
I think that we're going to get $1 million. So we
Right,
have to
that's
go
why we
on
signed it.
on that assumption. Don't change the numbers. We may get $5 million, but we have guaranteed $1 million. This is what we're talking about.
And we said the deal was you have our authorization to settle for no less than a net figure of $1 million for the association. That was the deal.
That's correct. Authority to settle.
That's what we wanted in here, that's all we're saying.
No problem. That's no
That's all you
problem.
got to do.
I'll put it in that contract and that contract. Is that okay?
That's common nice.
There's a few other things here. That's the paragraph here. We should have that as a cross.
I agree with that. He added the fact that it is agreed and understood this agreement is entered into on a contingency fee basis. If no recovery is made, client will not be indebted to the attorneys or for attorneys' fees, costs, or expenses. No settlement shall be made without full knowledge and consent of both attorneys and client. I can put that language about the $1 million in that section. And he added, it says, for the public adjusters group, meaning that
Last paragraph.
it's in the bullet part, where it says you don't owe any money if we don't get any money for you. I'm going to add the public adjuster in there. He's taking the risk. He's not going to get any of this 5% if we don't recover either, which is, thank you for doing that. I appreciate that. And then I can add the $1 million part in there too.
That's fine.
And then that one, I'll put that $1 million in there
Put the
too.
gross amount. Whatever it is above it, 35%.
guy at the end
Is that-
of
is
this
that okay with the
line,
rest
is he
of the
an
board?
attorney?
It's a
You don't
good
know.
spot for it.
Yes,
It's a good spot for it.
right, just put it right in there, that $1 million
I'm
part.
sorry, that's right,
And
that's right.
I have a question, I could be
Into
wrong.
this room, yeah, see, the
Wasn't the agreement that the percentage would be like a third, and if it goes to court, 40?
Yeah,
So if it does not go to court, let's say there's a, some kind of a miracle, and they give us a settlement that we can accept,
Yes.
are we paying a third?
the original lawsuit called for 1/3 before the lawsuit is filed, and then 40% after it's filed. The lawsuit was filed, they answered the suit,
Okay,
and we had no choice, they weren't paying any money until we filed the lawsuit. Now they're under court supervision. So we're beyond that, we're at 40.
I have another,
It's 40% of the attorneys.
I'm saying that represents all your court costs, or whatever you spend.
No, incidental costs are not part of it.
Incidental, okay, now we gotta talk, what are incidental costs?
It's all in the original
How
contract.
much is incidental
We
cost?
do not, I
How
do not have a copy.
incidental is incidental cost?
This is all negotiated in the original contract.
Thomas did not read the original.
Long meeting.
I have a question.
I'll get you the original contract tomorrow morning.
Glad you're back,
I
Alan.
have a question related to your wonderful
You
recent
deserve some
win
of this.
of 20 million, I believe, with a condominium association that's slightly smaller than the 600 some odd units.
Yes.
Who suffered a similar situation. And so my
Yeah.
question is, how,
At the end of this room.
how high are you going to go for?
Can't
it?
see,
I
he's
mean,
almost blind.
you're-
Well, I mean, our demand is going to be unreasonable because their initial offer was unreasonable. And somewhere in the middle is where the true damages are. But in your case, you're right, you have 644 units, I think, in here.
No, we have 832.
832.
And plus we suffered because of not receiving proper monies.
Exactly.
Number one, the people had to put out of their pocket a huge assessment, but number two, there's been lots of degradation of work that could not be done. Because we didn't have the money, they didn't do their duty towards us.
Exactly. That's a large part of the claim, actually.
The incidental are additions to your 40% fees.
Yes.
We want $1 million net after incidentals and fees.
That's exactly right. That's what you're
Absolutely.
like, $1 million check in your pocket, minimum, regardless of the cost of the incident.
Okay, but,
Right, that's what we agreed to.
We just,
That's including everything. The worst that could ever happen is if we settle this case, you'll get a check for $1 million. And we're expecting a lot more, so we're hoping. We think it's worth more.
Oh, my last question.
But in turn, let me finish this, let me answer your question. The Buckley Towers case is kind of obviously unique in that the place was condemned and there are structural damages to the two towers, meaning that the people couldn't even live there and they were all being thrown out of their houses and get nothing in the next month or so. So they actually had a retired federal military judge from New York fly down and preside over the trial. And it was that sort of emergency kind of thing, that these people were, the place was so dangerous they couldn't get in because the thing could collapse at any time. And there are a lot of other facts and circumstances with that. And actually, what we asked for the exact amount the jury gave us. And I'm not saying that this case, every case is different, stands on its own in terms of the damages. But that case was a little out of the ordinary, to be honest with you. I mean, when the whole place is condemned by the city of Miami, and no one can live there, and they're all going to lose their place, and they're going to get $0 for it, and they're going to be on the street. That was the sympathy of the jury heard on that. I'm not saying that there wouldn't be incredible sympathy for the jury if we went to trial against citizens in this case. And I think that they understand that. So I can just be optimistic. I mean, we don't get paid until you get paid, so it's not like we're sitting around doing nothing. We work on this case every day. So tomorrow will be a good day because citizens is finally coming out with a neutral person to analyze the damage.
my question is, being that you're our attorney presenting us with a legal paper form, what attorney do we use to review it?
Whoever you
That
want.
was
You
true.
can- Whoever you want to review. There's a lot of attorneys out there that are hurting. They could probably $250 they could review it.
Or more. I have just one other question. There is no chance of any past company or any other issues that this firm, the engineering firm or the, what do
The
you-
window guys,
window guy, there is no chance for them to claim, if someone puts a claim against them to something, it's not going to end up on us by virtue of signing anything. I mean, this is very clear that it's exclusive to the situation.
in terms of proceeds?
No,
If we
in
got
terms
proceeds-
of people claiming money's due, work
When you get
done.
money, if you ever got money, when you get money, or if you get money, you're talking about that, you don't
Yeah,
want people coming out of the woodwork?
Possibility of anyone that the firm
Any-
has hired.
No, there's no
Putting
possibility.
liens
To
on
the
us,
association for payment,
No.
like was done before.
like.
No, and if, I don't know whether my boss analyzed that or explained that during his last meeting, but if he didn't make it clear, then I can get something written to that effect, that you would be exonerated from anything that anyone would ever come back for. Because you're right, people do come, if you got a couple $1 million and people found out about that, they'd come out of the woodwork everywhere.
Claiming.
What we try to do is we try to stop that from happening before we get the money, like in the event of like Mr. Galante. Mr. Galante, we wrote a bunch of threatening letters to him. We didn't know whether he was fired from here before we were hired. As a public adjuster, he had a 10% contract. Now, we certainly didn't want him to come back, which happens in some of our other cases when money comes in. These people come out of nowhere and they say, I did all this work and I'm entitled to this. We got a release to that effect, which is why I can give you that contract for the 5%, knowing that his previous employer is not going to ask for any more money because I have a release that's been notarized by him saying he has no right to any of the money, any new money.
So whatever releases we would need, so that would not happen to us, is what we need.
Is exactly what you need, and I can get
Even
that.
the company you're working with currently, I mean, that this contract is about.
You mean
Well,
Mr. Lear?
we're dealing
The
with
new one?
him directly, so.
Oh, okay. Well, you
If you're dealing with him directly, if he's terminated for cause or whatever, he would have his own, if he spent a lot of time and he thinks he's entitled to something, then he would go, he would do whatever he needs to do, but I don't think that would happen in this case. That's why we're excited to work with him. And he's expended an awful lot of hours on his property already, so. Anything else? Just so I'm clear, I'm going to change, your change, sir, I'm going to change and add public adjuster, doesn't get paid unless you get paid. And I'm going to put in the net of $1 million minimum on both contracts.
And that will also stay on the public adjustment, is 5% in case he has excess costs, they're also excluded from
The 5%